Good afternoon and a huge welcome to the Next Your Employment webinar in the series providing you with essential employment law and HR updates. For those of you that are new to our webinars, we are of course Jones Chase, a firm of specialist employment lawyers, and we after a number of companies from PLCs all the way through to startups and also some fantastic individuals as well. And we have a very high success rate of looking after those that we represent. And we are delighted to have you with us. And I would just like to quickly introduce the team. So we have one of the firm's partners, Shona, who's speaking today.
Hello, good afternoon.
One of the firm's senior associates, Harriet.
Hi, everybody.
And also we've got the firm's paralegal, Don.
Good afternoon.
Okay, thanks everyone. And yeah, first of all, in terms of format for the webinar, if you want to ask us questions, please use the Q&A box. If you want to do that anonymously, please hit the anonymous button. If you don't mind your name being displayed, you can also use the chat box as well, which we'll also be keeping an eye on. It's quite useful for us to keep the flow of the webinar going if you let the rest of the attendees know what you're asking or what you're saying to us. And there's a drop-down box on the panel of the Q&A box and also the chat box to select all panelists and attendees. So if you use that option, that's great because everybody can see what you're saying. And again, it's just useful to keep the chat flowing. If you want to speak live to us, please write that into the Q&A or chat box, and either myself or one of the rest of the team will unmute you. And I should add importantly that we are recording this webinar to allow us to distribute it to those that couldn't make it at this time. So please do bear this in mind if you're asking questions on a non-anonymized basis. I should also emphasize that the points that we're covering today are not formal legal advice, and so much, particularly with this webinar as well, so much depends on the facts of the case, and sometimes the approach that you take in one case is not the approach that you will take in another. Therefore, please do not rely upon this webinar as constituting legal advice, and instead do drop us a line where we can have a sort of one-on-one discussion about that. And a quick reminder, the information that we're covering today is accurate as of 4 o'clock on the 30th of June 2022. Things in employment law always change very quickly, so do drop us a line if you have any further questions. We do appreciate that everyone's time is precious, and we're definitely going to finish at 5 p.m. today at the latest, if not before. And just finally for me for the moment, so we do like helping people and companies. So if you know of anybody else or any companies that that you think would work well with us, by all means feel free to introduce us. It'd be great to be connected with them. Yeah, that's great. So today's webinar with a special topic, a focus topic of some other substantial reason. And here to introduce the concept is Dominic. So I'll just hand straight over to Dominic.
Thank you, Dean. So as Dean mentioned, I will be providing you with an overview of one of the potentially fair reasons for dismissing an employee before we look into it in more detail later in the talk. So an employee can generally only bring a claim for ordinary unfair dismissal if they have at least 2 years continuous employment on the effective date of termination. There are a number of unfair dismissal claims where an employee does not need to have any minimum qualifying period of service, but that's not something that we will be covering today. So there are 5 potentially fair reasons for dismissal under Section 98 of the Employment Rights Act 1996. So the dismissal of an employee may be fair if the employer can show that it is for one of the specific reasons set out in Section 98(2) of the Employment Rights Act. These are capability, conduct, redundancy, breach of a statutory duty / illegality, or for some other substantial reason of a kind, such as to justify the dismissal of an employee holding a position which the employee held. This is more commonly known as SOSR, which I will refer to it as throughout the talk, and this is the focus of our talk today. So SOSR is a residual catch-all potentially fair reason for dismissal. If the employer's reason for dismissal falls outside Section 98(2) of the Employment Rights Act 1996, it must fall within the SOSR category if it is to qualify as a potentially fair reason at all. So there's no statutory definition of the term or statutory guidance. However, the relevant authorities on point make clear that the reason must be substantial. In general, provided that the reason is not wholly superficial or insignificant, it may be classed as substantial. Nevertheless, the interpretation of what is substantial is subjective, and it will depend on the facts and the type of the case. The reason must also be of a kind which will justify the dismissal, rather than any lesser sanction of an employee holding the job that they actually held, such as a written warning or a performance improvement plan. So looking at a two-stage test for a fair dismissal, and the statutory test for unfair dismissal has two separate stages, and looking at this in the context of an SOSR dismissal. Firstly, the employer carries the burden of proof in showing that the SOSR is the sole or principal reason for the dismissal. To satisfy this stage, the employer needs only to establish an SOSR reason for the dismissal, which could justify the dismissal of an employee holding the job in question. It is not necessary to show that it actually did justify the dismissal. We will refer to different SOSR reasons later in the talk, but at the first stage, the tribunal must not consider the justification, reasonableness, or fairness for dismissing for SOSR. Secondly, the employer must then show that the decision to dismiss for SOSR was reasonable in all circumstances. This does include the size and the administrative resources of the employer's undertaking. This will be determined in accordance with equity and the substantial merits of the case. For this stage of the statutory test, the burden of proof is neutral. Accordingly, the tribunal will need to investigate the reasonableness of the dismissal, but the onus is neither on the employer to prove it was fair, nor on the employee to prove that it was not. So there is some overlap with other potentially fair reasons that I previously mentioned, and where facts fall squarely within one of the section 98.2 reasons, which as a reminder are conduct, capability, illegality, and redundancy, they then cannot simultaneously be SOSR because by definition, SOSR is some other substantial reason. In some cases, the reason may appear to fall within one of the section 98.2 reasons, but in fact does not. Sometimes it may be difficult to tell which was the sole or principal reason for dismissal, and indeed which section 98.2 reason it falls within, especially in dismissals where the employer puts forward more than one reason. In these cases, it may be advisable for employers to plead a section 98.2 reason and an SOSR in the alternative. However, there may be some cases where the employer's failure to properly characterise the reason for dismissal affects the fairness of the dismissal. For example, if the employee is guilty of behaviour which results in a breakdown of working relationships, the reason for the dismissal might be misconduct or SOSR. It's important for an employer to be alive to this distinction, since a different procedure would be called for if the matter was dealt with as a misconduct issue, rather than simply on the SOSR basis that working relationships had broken down. So now looking at some common examples of reasons for SOSR dismissals in the workplace. So the first one that we're going to look at today is business reorganisation. And dismissals that are the consequence of a business reorganisation are often by reason of redundancy. However, in cases where there is a restructure which does not give rise to a redundancy situation within the meaning of the Employment Rights Act 1996, such as where the need for employees to do work of a particular kind does not cease or diminish, merely as being reorganised into new different roles. In this instance, redundancy cannot be relied upon as a potentially fair reason for dismissal, but SOSR potentially can be. Business reorganisations also often entail changes to employees' terms and conditions. Dismissing an employee for his or her refusal to accept proposed changes, either within the context of a business reorganisation or not, can also amount to SOSR, and Harriet will be looking at this in more detail later in the webinar. And the second example of SOSR dismissals in the workplace that I'm going to be looking at is the breakdown in trust and confidence. So employers sometimes maintain that they must dismiss an employee because of a breakdown in trust and confidence. The Employment Appeal Tribunal has at times criticised the use of the notion of trust and confidence. While loss of trust and confidence has been held to be an SOSR reason, and cases continue to be put forward on such terms, reliance on the loss of trust and confidence alone will not usually be enough to establish a fair dismissal, and tribunals should in most cases look carefully at the surrounding circumstances. And this is something Shona will be looking at further in her section. So that's all from me.
And that is the first time I've done that in 2 years, actually. So there we go. Right, I do apologize, I was on mute. Just want to say thanks so much for doing that, Dom. That's great. And as we've mentioned, we will be having a more general chat after we've done the main sections about SOSR generally. Maybe speaking about a few interesting cases that we've been involved with ourselves as well. But just getting through the sort of the content that we've already prepared. So the second part of the webinar is going to be dealt with by Shona, and Shona is going to speak about practical steps in an SOSR dismissal process if an employee is refusing or making it difficult to be managed. So over to you, Shona.
Okay, thank you, Dean. Thank you, Dom. The SOSR reason that frequently gets relied upon and that Dom mentioned in his section is this breach of trust and confidence. And ordinarily, you hear that phrase of breach and trust and confidence when the employee is saying, this is constructive dismissal. I'm leaving, I'm walking out of my job, and I'm doing it because you, the employer, have acted in a way that is a breach of trust and confidence. You've gone to the very root of the contract and you have destroyed that employment relationship. So the SOSR is the employer equivalent of that argument. Hold on a minute. You, the employee, have acted in a way that has breached the trust and confidence between the two of us, and that you have broken down that employment relationship. And it's an irreparable breakdown. So if you can just think of the length an employee has to go to show of constructive dismissal, that's how far the employer has to go to show the equivalent test, a breakdown of trust and confidence, and irreparable damage to that employment relationship. And as Dominic said, the tribunals do not like to have that on its own. It's the headline. That's what is the end result of what has happened. And often that irretrievable breakdown of that employment relationship and that breach of trust and confidence that the employer is relying upon is a conduct thing. It's something that is based upon misconduct or indeed gross misconduct, and therefore they have misdescribed what their reason for dismissal is if they use instead some other substantial reason. And you have to be very, very careful if you misdescribe your reason for dismissal, because for both conduct and capability, if that is your reason for dismissal, if the employee succeeds in showing that's an unfair dismissal, the employee can be awarded extra compensation if the employer has failed to follow the ACAS code, and that's an uplift of compensation of 25%. So whatever the employee is awarded as compensation, there is a 25% uplift of that amount for failure to follow the ACAS code for capability and conduct. And if you have relied upon an SOSR reason instead of conduct, then you will have failed to follow the ACAS code because you won't have followed your conduct disciplinary procedure for the actual dismissal in itself. So you can get caught by the tribunal proceedings, and then a financial deterrent is made against you, or a financial award is made against you because you've chosen the wrong reason. So if we get back to our SOSR reason, and when does this irretrievable breakdown in an employment relationship, when does that happen? When can an employer rely upon that and it doesn't tip over into conduct, or it doesn't tip over into gross negligence, which would be capability? And we've had a few recent cases where the argument has been used by the employer where they've relied upon the dismissing reason as some other substantial reason. And I thought it would be helpful to go through the facts as broadly as we can in relation to cases, so that you can understand what the employee did and had to put up with until it reached that decision. This is an SOSR dismissal. But before I go through that in particular, this is all relying upon an old case of 2011, and it's a doctor who's a consultant. So he's a Mr. Isaias. He was the doctor in this particular case, and it's North Glamorgan NH Trust. And let me describe Mr. Isaias to you. The tribunal and the EAT described him as a man of considerable charm, And he is also someone who struck us as being inclined to take a blinkered view of what people think of him, and as someone who thinks starkly in terms of black and white. The fervour with which he sought to put right what he genuinely sees as the injustice of his dismissal at times bordered on the obsessive. So that's in context of what we have in relation to Mr. Isaias. Now, that case involved this particular consultant joining the North Glamorgan NHS Trust, and within a short while of joining, making a complaint about two of his fellow consultants in relation to their clinical competence. So he thought that two fellow consultants of his weren't competent in relation to the job that they were doing, and he let his superiors know that was the case. He then made other complaints about other colleagues within his department. And this ended up with those colleagues, and not just those against whom complaints have been made, but 9 colleagues signing a petition to say that the allegations raised by Mr. Isaias had to be looked into, because this was destroying the employment atmosphere within this particular NHS trust. It was detrimental to the patient experience, it was detrimental to the health of the other consultants, and therefore this had to be looked into by the NHS trust. The NHS trust did do a review of the issues raised by Mr. Isaias, and decided that actually he had described what he saw as clinical incompetence, and decided that would be it, leaving it there. But then went on to say, because of the detrimental impact on the whole working relationship and the petition of 9 other employees, it had no choice but to decide that there was an irreparable breakdown of the employment relationship with Mr. Isaias, because he didn't want to work with people that he believed were incompetent. And the NHS Trust described that as SOSR, an SOSR dismissal. So we had one employee claiming 2 other people were incompetent, generally complaining about the standard of work of others, and then a petition by other employees in that group against the person that makes those complaints. This is not misconduct. Mr. Isaias didn't raise the incompetency points because he was blatantly trying to be provocative, nor did he bring complaints. He was obsessive. He did think that he was right in what he was saying. And the petition by the other employees, again, was not misconduct by them, nor was it capability, because those employees, again, genuinely were distressed by the complaints and the way that Mr. Isaias was behaving. And so this was an SOSR dismissal and accepted as such by the Employment Appeal Tribunal. So that gives you a flavour of what has to have happened in a workplace. There's not a personality clash either. Mr. Isaias got on with these other employees personally. It was professionally that he had the difficulties. So let me go to what you as an employer have to look out for when it comes to eventually thinking, can I rely upon that SOSR reason? So it's an employee's activities. I'm sorry if you can hear background noise. Somebody's having lots of fun at work, and it's not me. It's behind me. Anyway, they're enjoying their afternoon. So let me get on to what an employer has to do when it comes to and look out for this SOR reason. If an employee raises a significant number of grievances, and those grievances relate to the way the setup of the organisation, how things are responded to generally, how their manager manages, just generally complaining about what is going on. They may be legitimate grievances. They may legitimately believe what they're saying. They may even suggest at a later date that they blew the whistle at that stage. But if it gets to a stage where that employee then raises the matter so often about so many, and reviews are done, and based on those reviews, it's clear that the standard that's being undertaken by the other employees is a standard that the company wholly accepts, and that the employee has a misguided view as to what should or shouldn't be done, has their way of doing it, but that might not be everybody else's way, then that can be relayed by management to the employee, and you can talk through with them how this can be remedied so that they can accept that maybe other people do things differently to them, that there's a code of conduct within the organization on how things are managed, how cases are dealt with, how sales are undertaken, etc. And so that there is a basis for the employee to know that here's the scope of how you do it, what you do, when you do it. Let's all stick within this scope of how, what, when. And if you have a problem with that, come back to us. But that's not something that needs to be a grievance, etc. That can be something that we can deal with. If that employee then still is querying what's being done by whom and how and when, then again, you can ask the employee for the details of that, look into it, report back to. But there does come a point where you have to say to the employee that the way you are managing them is a reasonable way of managing them, and that as a result, if they carry on raising issues within the workplace, this makes them unmanageable. Or if the employee themselves says, and this is happening more and more with remote workers, leave me be, let me get on with me doing my job. And therefore they're refusing to be managed because they think that the way they're doing it is the only way, and they won't let the manager intervene with the company way that's now been set within a protocol or a way of working or a guideline for the employees within a particular team. Now, again, there isn't a personality clash here. There is a genuine mismatch on how matters need to be managed within the organization. And the employee who's at risk of being dismissed of SOSR is not understanding that their way is not the only way, and that other employees, there is scope within this a reasonable approach to the way work can be done. If the employee is still not satisfied with the way that either they're being managed or the ability of others, etc., then you can and should suggest mediation for that. And that mediation should take place before any decision is taken with a disciplinary decision. And I say disciplinary, we're outside the remit of disciplinary, an SOSR decision. So a decision can be taken, but you must have a mediation. The problem with mediation is you need everybody to participate in that. And there may be employees that don't want to. And the reason they don't want to is because they think that mediation won't be fairly undertaken, and that individual that's always causing the problems will be given more leeway, and therefore, he's already said awful things to me, I don't want to be in a mediation with that person. If you attempt to have the mediation and you've legitimately made that attempt as an employer, you can record the fact that that's the case and then move on to having some other substantial reason meeting with the employee to say, we're having you here today, and the reason is, and it's that catalogue of issues that has occurred in the background. They don't amount to capability. The employees are capable of doing their work. It doesn't amount to misconduct because they have the right to have a view in the way that they do, but it's a breakdown of the employment relationship because of this irretrievable situation where we're trying to get him in line with everyone else, but we can't. And that's where you could rely upon the SOSR reason. Now, at that stage, an employee is likely to say, I blew the whistle way back a few months ago. This is based upon me blowing the whistle, or it's some discriminatory issue because for whatever reason, those people are working in a particular way because they have a particular characteristic and I don't, or I've got this characteristic and that's what causes this. And you have to deal with that at the time. They may have raised this issue earlier in the proceedings, and break the link between what they believe is whistleblowing and the steps that are being taken, and break the link with that discrimination element. So it's quite a slow, painful burn but it is that slow, painful process to get to the stage where you've gone through all the issues the employee has raised. It's not conduct, it's not capability. You've offered mediation, you may have had your mediation, or you've offered mediation and you can't get all parties to mediate, or you can't agree the remit of that mediation. You then have some other substantial meeting with the employee, you put to them all the points that's causing this potential breakdown in trust and confidence, and then you have your meeting to decide this is what we're going to do. It is a dismissal for that. Dismissal in this situation, I would always do dismissal with payment in lieu of notice. I would not dismiss without notice. You're not frog marching them out. You're not saying this is gross misconduct or gross negligence. You're saying this is some other substantial reason. So I would pay notice with that. And in that letter, it would be a thorough breakdown of why you've got to the breakdown that you've just described. So this, as I say, it's very fact-based. So to tick boxes thinking, yeah, I've done that, yeah, I've done that, yeah, I've done that, is all well and good, but you have to look at the facts of what you've done in that particular case to decide, have you got to the stage of some other substantial reason? So that's it. Thank you.
That's great. Thanks so much for showing. There's quite a lot to discuss with this as well. And what we can do, we move quickly into Harriet's section, and then we'll have a general discussion at the end. So we'll keep it all together that way. If the people behind you carry on making a noise, I can pop around and dismiss them from the webinar for some other substantial reason, namely noise, if that happens again. So just let me know. Harriet, we're just going to move on to your section, and you're going to be speaking about SOSR dismissals in the context of refusing to accept changes to terms and conditions. So over to you, Harriet.
Thank you, Dean. Yeah, so looking at a slightly different aspect of some other substantial reason dismissals, and it sort of demonstrates the sort of wide variety of types of reason that might lend itself to this kind of category. So Don mentioned earlier the example of SOSR in the context of business reorganisations and changes to terms and conditions. So as Dean said, I'm going to focus on where employees refuse to accept changes to their terms and conditions, which may be brought about by a business reorganisation, but may also arise in other contexts. So as you probably know, as a starting point, a contract can only be varied in accordance with the terms of that contract or with the parties' agreement, so employer and employee agreeing. And where an employee refuses to accept a change to their terms and conditions, and the employer dismisses for that reason, often having offered the employee new terms and conditions, the reason may constitute SOSR, depending on the circumstances. But these kinds of cases may not be straightforward, because an employee is contractually entitled to resist a unilateral change to their terms. And in some cases, where the change amounts to a breach of a fundamental term of the contract, the employee may be entitled to resign and claim unfair constructive dismissal. And that may also be the case if the employer tried to impose the changes without any form of consultation. So an employer does need to be cautious before dismissing in these circumstances, but let's have a look at what they have to be able to show to potentially justify this kind of dismissal. So firstly, we're going to look at the fact the employer must demonstrate that the changes were not imposed for what's been set out in case law as being arbitrary or capricious reasons, but they need to be because of a sound business reason, and these come from case law. And I think an interesting point here is that when you talk about a sound business reason, it doesn't have to be a reason that the tribunal considers sound, but it comes down to one which a reasonable employer would consider sound. And tribunals need to make sure they don't substitute their own opinion for that of the employer on the question of whether the change is of the benefit to the employer's business or not. And there was a tribunal case where the EAT actually overturned, this back in 2005, overturned an employment tribunal's decision that the employer had failed to demonstrate that the change to the shift system in this particular case gave the employer such a discernible business advantage that the employee's refusal to accept the change could not amount to SOSR. And the EAT said this was wrong, and the tribunal shouldn't have allowed its own assessment of the new shift system to influence its decision, and actually was placing an even higher burden of proof on the employer by ruling that the advantage to the employer had to be so substantial that it mitigated the consequences of the dismissal. and this isn't right, and the burden is not nearly so high. So there's no need for the employer to prove that the change was crucial to the survival of the business, or even that there was a particular amount of improvement achieved in the business, or that it was special or extraordinary. So it's quite a low threshold. But importantly, whatever that reason is, the employer must be able to provide evidence to demonstrate the business reasons for the change, and to be able to show that they're not trivial. But as we've just discussed, it's not an onerous requirement, but you would need to have some kind of evidence. So when considering the fairness of a dismissal, a tribunal will look at the full context of the business reorganisation or the proposed change. And as generally with employment law, no one relevant factor is going to be looked at the exclusion of all others. So as with shown as type of case, it always depends on the specific facts. And in the context of business reorganisation and the consequential changes to terms and conditions, this assessment usually of reasonableness usually entails a balancing act. And the tribunal would consider the reasonableness of the employer in dismissing the employee with the reasonableness of the employee in refusing to accept the change. And obviously, while dismissing an employee for refusing to accept a change of their terms and conditions may be reasonable in the circumstances, it doesn't follow that the employee's refusal to accept them is unreasonable, and their interests may just conflict and be irreconcilable, to the extent that a tribunal may accept that an employee was reasonable in their refusal, but then go on to find the changes were nevertheless reasonably imposed by the employer, and that the dismissal was fair in all the circumstances. So you can see the balancing act that a tribunal needs to go through, and should not be substituting its own view of what was reasonable. And we always come back to the test of whether it was in the range of reasonable decisions which a reasonable employer acting reasonably could reach. And a sort of an example here is, if you had a case where an overwhelming majority of the workforce do accept the change to the terms and conditions, which is often the case, and obviously if most people accept the change, they may be implicitly acknowledging that the employer's position was actually quite legitimate. If you have an individual, often there's one or two who won't accept the change, they may then struggle to show that their dismissal for refusing to accept the change was unfair. And obviously, as the employer, you'd want to have the evidence that everybody else seemed to think that it was reasonable. So I mentioned that there's lots of factors that the tribunal will take into account, and no one factor is more important than the other. So looking at some of these, when the tribunal is assessing the reasonableness of an employer's decision, if they haven't got the employee's agreement to the proposed changes. So they would look at things like the employer's motives for introducing the changes, obviously the employee's reasons for rejecting the changes. They look at the process that's been followed, so were the employees given reasonable warning of the changes, were these changes and the sort of the full effect of them sufficiently and clearly explained to the employees. Has the employer undertaken an assessment of the impact of the changes on the employees? Has it considered any alternatives? Could they have done anything differently? Has the employer attempted to attain the employee's voluntary agreement to any of the changes? Probably, in most cases, you would expect them to have done that, but rather than just imposing them, have they actually had a dialogue with the employees? And whether a reasonable and genuine consultation process with the employees has taken place, that's absolutely crucial here. And that will include listening to the reasons for rejecting the changes and responding reasonably to these objections, and making concessions where reasonable and possible to do so. As I said before, whether the majority of the employees that have accepted the changes, and there may be a recognised trade union involved, and have they recommended or objected to the changes. So it's clear that, even if you have a sound business reason, you do also need to go on to follow this fair process and be able to demonstrate what you've done, and ultimately have the evidence of that available. So just to sum up by way of conclusion, the tribunal needs to look at both the employer and the employee's perspectives and decide whether the advantages to the employer outweigh the disadvantages to the employee. But it's clear that employers aren't going to be required to establish an onerous level of commercial advantage of the business reorganisation, or to prove that it is vital to the survival of the business. So it's worth thinking about this, particularly if you have 1 or 2 employees who aren't willing to accept the changes, as long as you've got some kind of good sound reason, you may well be able to move ahead with offering them the change terms, but ultimately terminating their employment. But make sure you do all the consultation and those points that I've set out. That's all I wanted to say.
I just wonder, say you've got 100 people affected by that shift change and 98 accept and 2 don't. Does that help sort of sway the balance of, well, look how good this is, 98 people. But if you had the situation where 48 took it up and 52 didn't, then it sort of shows, again, it shows the other way. So yeah,
I think it's certainly it's one of the relevant factors, isn't it? And I think, you know, with anything, when you're looking how reasonable are these employees being in rejecting it, I mean, they may have their own very specific reasons for not accepting the change, and obviously that would be something that the employers should look at and listen to what they're saying and respond. But as you say, if you've got 98 out of 100 employees saying, yes, I'll accept the change, that's definitely a relevant factor. And I think that's going to be something that may weigh sort of quite heavily when the tribunal is looking at this balancing exercise in terms of the sort of disadvantage to the business. So yeah, and I think if it was more evenly matched and you had a lot of people saying, you know, no, we're not going to sign up to these changes, you would expect there to be quite a good reason why, and then that balance might go the other way. So yeah, I think it's definitely a relevant factor.
Yeah, that's right. And I think just on those cases, there's no magic percentage, is there? There's no from case law. And every time I've worked on a contract variation exercise, and you, as a lawyer, you do all of the work, you put it out there, and then you're just waiting, you know, please can everyone accept, because the letters are so well written, and there's always 1 or 2 I find who are just absolutely not having it. And then you just need to consult with them a little bit more and really flesh out why aren't they doing it, but before you hit the dismissal button for SOSR, I think. So a bit more consultation with them. But yeah, you're you're absolutely right in terms of there's no case law on this in terms of a magic figure, but if it's a 50-50 split, 50% accept, 50% don't, I think you have to be very, well, I wouldn't advise to dismiss in the circumstances.
You also may not want to dismiss half your workforce in one go.
Yes, exactly. That's more practical problem. Exactly.
Yeah.
And re-engage is the important part. Yeah. And re-engage on new terms and conditions.
So I suppose you've got 2 bites of the cherry as well, because you've collectively consulted. In that 100 example, you've had a collective consultation. So you've hopefully got as many on board as you can then, over and above the individual. So yeah.
That's right. And okay, we've got a question for the attendees, so just to let you know, and we'll be asking you that in a second. But just in the meantime, we've had a question in, for the people watching the webinar via a recording, without naming the name of the person that asked it, just in case it's anonymous. But hello, it's been a long time since we spoke, but nice to hear from you. And the question was one for Shona, who mentioned mediation, and the question is, who would Shona recommend carries out the mediation where there's a potential breakdown in the employment relationship? Can this be done by someone in another part of the organization, including in another country? And in this particular case, the person doesn't have an external provider, and it takes up to 2-3 months to set up an external vendor, which may be too late. And Shona, you kindly typed the answer earlier, which you said, yes, it's a good plan to use someone with mediation skills from another part of the business or another country, and not involved in the situation to date. Unless there's anything you want to add, Shona, we can move on.
I just, because the person has rightly pointed out, time is of the essence with these matters, because as each week goes by, the irretrievable breakdown is becoming more and more. I know irretrievable means it's irretrievable, but it's getting worse and worse. And morale, you'll get sickness coming out of it. Yes, so time is the essence.
Exactly. There's a number of cases where I think we've all worked on where the significant toll that having a relationship breakdown, particularly in the smaller business where it can't be absorbed due to the size of the business, can be exceptionally damaging and draining for the senior managers as well. Okay, so I did mention we'd be asking the attendees a question, and just for say 30 to 60 seconds, purely for a little bit of fun, maybe as fun as these webinars ever get, can anyone name a SOSR reason other than the ones that we've mentioned? So the ones that we've mentioned so far is you can dismiss lawfully in certain scenarios for a business reorganization, also if employees refuse to accept changes to terms and conditions, and also a breakdown in trust and confidence. So Does anybody else out there, other than the employment lawyer or two who's also watching? So just hold that back for now. Can anyone else name a SOSR reason? And just put that in the chat box. You can do that anonymously if you want, or in the Q&A box. And if you get it wrong, it really doesn't matter. It's always good for people to participate in the webinars because it's a good way of sort of learning and testing your knowledge as well. So there's a number of different reasons, and we will go through them. But can we get 3 from all the attendees? So we'll just give it 30 seconds. Nothing so far, I don't think, but that's okay. Oh, here we go. Oh, popping up in the chat box. What have we got? Sorry, I shouldn't laugh at that. We nearly had a situation where someone's personal hygiene was a constant issue. And can you talk about, okay, there's another question, and we'll come on to that. So any other SOSR reasons that people are aware of? Okay, they're coming through. Relationships at work. Yes, correct. Well, then that's one. We've got 2 more to get. And Dom will tell you a little bit more about relationships at work. Refusal to work with new technology. Come on to that in a moment.
Could potentially be a redundancy situation because the job and the way it's done, potentially. But yeah, it's a nice suggestion, actually.
Okay, so so far we've got somebody's personal hygiene, and that's what I like about SOSR reasons, is that can literally encompass anything. Shona, we were discussing that case earlier from 1975, which I dare not read the facts out. That's all I'm going to say about it. But yeah, pretty interesting. So we've got relationships at work, refusal to work with new technology. Oh, another client relationships. Yeah, that is one. So client relationships is indeed one. Relationships at work. Just looking for one more. Whilst we're waiting for any further answers to come in, I think I'm sure the team will correct me if I'm wrong here, but this is an area of the law where you could very much go to the tribunal and create new law. You'll then have a reported decision, unfortunately, with the name of your company. But things do change. New SOSR reasons come up all the time. I think I'm not aware of a refusing to work with technology SOSR case, but I think that could well be one, or the redundancy point that Shona's already mentioned as well. Conflict of interests. Yes. Yeah, insofar as a third-party relation, but conflict of interest, I think, could be one as well. Okay, so we've got our 3 here, which is good. But
should we chat about personal hygiene? Nothing personal to you, but I just think it's an interesting one to raise, and actually it's one which Harriet mentioned a very long and comprehensive list of the alternative things you must think about when someone doesn't want to make a change to the terms and conditions. And I think that with the personal hygiene point, there's probably quite a lot of alternative solutions that you can come up with that will try and resolve the situation, that somebody does not lose their job over I'm going to assume it's lack of deodorant, but I don't know, but let's go with lack of deodorant. So I think maybe again, one of the points that Dominic said at the very beginning was when you've got the 2-stage test with all the dismissals, you've got the reason that could justify dismissal, and then you've got this second section, which is the reasonable and the range of reasonable responses, and they take into account the size and administrative resources of the employer. So I'm sitting as Google, and somebody's got a personal hygiene thing. Google could afford to put that individual in a room of their own, and that personal hygiene thing is sorted, provided that it doesn't seep under the door. But so there is the size and administrative resources, but I think that it's a conversation that could be had with the individual, a chat. It could actually, there could be some element to do with some condition that the individual has that as a result of that, they don't know. I know that there people have no smell, so they don't know that that's a problem. So that could be the issue. So to me, there's quite a few steps to lead up to we know what the problem is, why is it being caused, and how could that be remedied, and what are the alternatives to it within that size and administrative resource.
Yeah, that's right. And I think you're right, Sharon. It's always, the employee should always look to see how they can fix it before that second stage part of the unfair dismissal test. So they would need to look at other alternatives as well. And I think perhaps one of the keys is in the word substantial. So from other examples I'm looking at here, you know, there usually has to be some sort of substantial disruption to the business. So whether this person has to work in a close-knit environment with a team just for collegiality, whether the team is so dysfunctional because they're so upset by it's been confirmed in the chat, it's a body odor problem, a BO problem. If it's having a substantial impact on that team's, how they work together, then maybe obviously try to fix it, try to speak to the person, mediate, give alternatives, try to move them around, change working rotas, whatever you can do. But ultimately, I think if it's a substantial impact on the business, we need to look at that as well.
Secret Santa present that could resolve. But no, I agree. I think there ought to be a resolution to that.
Yeah, and I think as well, there's a few things I was going to mention, is that what we're dealing with here is different to misconduct, because usually with misconduct or gross misconduct, there has to be an element of knowing what the rules are and willingly breaking them, knowingly doing something wrong. And that's different with SOSR, because you don't have to know what the rules are and intend to break them. And that's one of the problems with misconduct. If someone's making a genuine innocent mistake, and if the person's very good at the job and it's not performance related, then we are stuck in the middle, essentially. And I think one of the things with SOSR is that employers never readily, well, unless it's in the case that you mentioned, or that we discussed today, employees don't naturally gravitate toward using these reasons. It's usually when they come to lawyers, well, we can't use this reason, that one, or that one. Maybe we can try one of these. But I think it's worth mentioning, and we'll run through some examples now quickly. It's worth mentioning them to get people to think about them as a viable route to dismissal, where dismissal has to be made. Just to very quickly run through some comments. So yeah, we've already had we've already had the BO issue. Client relationships, yes. Conflict of interest, I believe so. Reputation of the business, thank you for that. Yes, although you got to be very careful with those cases, but yes, that can be an SOSR reason. So I think, Dominic, you were going to mention a little bit more about personality. Oh, Shona, sorry, what was
Yeah,
it?
sorry, Dean, can we just pick up the question there about reserving the right to vary the contract clause? Because,
of course, yeah,
you know,
sorry.
there's, just about the variation. So there are general variation clauses, usually at the end of a contract. They're usually under the heading miscellaneous, and they're again catch-all. So the company reserves the right to vary the contract. Because they're general, you have to still act reasonably in terms of how you rely upon that clause. And Harriet mentioned in her talk about you clearly can't act in a capricious way. And so from that clause, it's there, it's good, but it's not something that you can rely heavily on because it's a general catch-all, and you have to act reasonably in the way that Harriet has described in full in any event. There may be clauses, however, within the contract itself that specifically vary a particular clause. And the most obvious one is probably place of work. And within it, there's a mobility clause. So your place of work is X, but we reserve the right specifically to move within 30 miles or an hour of distance from the company. And again, even though you've got that specific clause there, you have to act reasonably within the confines of that clause and implement it in a reasonable way. And many of the points that Harriet listed are equally relevant to that. So yeah, that's how I'd answer that point.
No, that's right. Thanks very much. Okay, we've got 10 minutes left, so please keep the questions coming. We have maybe a little bit of time right at the end. But Dom, you were going to mention a couple of things about personality clashes.
Yeah.
Not ours, I should add. But...
No. And just a quick point, I suppose, on the personal hygiene, I suppose it's more prevalent now because especially with virtual interviews, and if you hired over lockdown, you probably didn't realise when they came back into the office, etc. But no, as Dean mentioned, I'll look firstly at personality clashes, and that is something that Shona has mentioned, and I'll just give a quick overview of that. And it does have some overlap with breakdown of trust and confidence, but as Shona mentioned, it's not, they don't always combine. So personality clashes or conflicting differences between colleagues can amount to some other substantial reason. However, to do so, the conflict would have to be causing substantial disruption to the business. So similar to, as Harriet mentioned, the tribunal will expect the employer to take reasonable steps to solve the problem without resorting to a dismissal. So this can include redeploying one of the workers, changing work patterns, and attempting to mediate. So it may be more difficult to dismiss for personality clashes where the clash is due to the employee's conflicting views, as opposed to one employee's conduct or attitude, particularly where the views are based on a belief which is protected under discrimination law. So in such cases, the employer faces the risk of a possible discrimination claim, as well as a claim for unfair dismissal, if it dismisses one or perhaps both of the employees involved. Would you like me to talk about pressure from third parties?
Yeah, I was just going to say, Dom, as well, just on that last point, is the famous Liddell case, wasn't there, where, well, I'm looking at it here, the employer, there was a conflict between someone's religious views and another worker's sexual orientation. And within that case, the, where is it saying it here? Sorry, just bear with me. It's an example of a case in which competing views over sexual orientation and religion culminated in the employer dismissing one employee fairly for SOSR. So it goes to show that even where you've got a double discrimination case and you're stuck in the middle, SOSR can be used lawfully to dismiss somebody, even though it could be discriminatory as well, arguably. Sorry, Dom, yeah, yeah, and I think the other area is pressure from third parties. So if you want to explain that, would be great.
Yeah, so someone did mention in the chat box relationship with clients. So potentially where a third party, which can be, of course, a client, customer, or supplier of an employer, requires an employee's dismissal, the dismissal could be regarded as fair for some other substantial reason. A classic example does involve a large client refusing to work with the business whilst a certain member of staff still works there. And this could happen as a result of a breakdown in relationship between the two parties. The case law does indicate that the reason for the third party's request is largely irrelevant. However, what will be relevant is how important the third party's continued business is to the employer and how serious or definite the threat by the third party is. And as we've mentioned, there are other areas of some of the substantial reasons, but it does largely depend on the facts of the case. Other examples are expiry of a limited term contract, breakdown in relationships between shareholders, and reputational risk.
Yeah, that's right. And I think just in the sort of final moments of the webinar, because relationships at work, relationship risk have been mentioned in the chat box as well. There's only a very limited number of cases that have been reported on this, and I think importantly, employers need to avoid a knee-jerk reaction, because and that can happen where something quite seemingly catastrophic happens, but it should be thought through before you do this, because there's quite a high hurdle, as there are with many of these cases, to go through. So and you've got to look at alternatives as well. But yeah, an employer can dismiss somebody where continuing to employ them could result in a reputational risk to the company, and one that is separate to misconduct. So we had a case recently where we were discussing it earlier. Somebody did something pretty unbelievable, and it hit the public forum. But that was a clear misconduct case. So we're not talking about those types of cases here. It's specifically ones that don't fall into the misconduct category, and they are obviously fewer and further between.
I suppose if you did something in your private life that was, let's stick with your phrase, pretty unbelievable, and for some reason it hits the headlines, and nobody knows who you work for, so you didn't do this something unbelievable in your work uniform. It still could have reputational damage, because if somebody does a search and they find out where you work, etc., that still could have reputational damage on the company. So I suppose in relation to a lawyer, if we did something that was an out-and-out lie, then that would affect the integrity, and that affects the integrity of the organisation, even though it's outside of work as well. That could be SOSR, because that's not conduct, that's not misconduct in work. I have to say one proviso to that. Often when you see disciplinary policies, they have this list of what amounts to gross misconduct. You often see reputation of the business on that list. If you create a disreputable situation for the business, that's on that list of gross misconduct. To me, if you then try to make that SOSR, the tribunal will pick you up to say you're hiding behind SOSR. You should have followed a conduct process, and the fact you didn't could end up with an unfair dismissal and that ACAS uplift, because you've fallen into that. So do check your list of what you've got as under the heading gross misconduct, because that is what you're saying it is. It's misconduct rather than the SOSR thing. Some companies also have SOSR policies where they set out again, okay, so that's our list of conduct. This would be our list for examples of SOSR, and Dominic's provided a good list here today. But yeah, that could be helpful, that you then are clearly within that remit and you're not at risk of that 25% uplift, and everybody knows what SOSR is to an extent, or what it could be.
Yeah, that's right. And I think if having that policy as well would be useful for managers to see, because quite often the people attending like these webinars or dealing with employment lawyers may not be the ones managing the team in particular. So having an SOSR policy could be useful, because quite often people or employers are left scratching their heads where there's a case which falls in between. It falls in between performance and there is no misconduct. In the case you mentioned earlier, the person fundamentally believed in something and wasn't committing misconduct in any way for believing it, rightly or wrongly. And that person's performance is very good. So I think one of the purposes of the webinar today really was just to bring this more to the forefront of people's minds, that it can, in certain circumstances, be a very, very useful tool in the employer's arsenal. We've just had a final, we've got 2 minutes of the webinar left. I'll just go very quickly on this. I'll just read it out for the purposes of people watching the recording. So without naming any names, a client has had it where colleagues had a fight with members of the public after too many drinks at a work Christmas party, and the story ended up in the Evening Standard. Oh, wonderful. Luckily, the company's reputation wasn't damaged as far as they were aware, but certainly, but we certainly started to explore which avenue that had to be taken had that not been the case. So if this,
I would go with misconduct, gross misconduct there, because it's a work Christmas party. And I would, because also you'll remember back, sometimes with SOSR, the majority of cases you pay in lieu of notice with it. You're not frog marching someone out. This one, I don't think you would be able, you would have to pay notice with that if there's been a fight at a Christmas party. One of the things, I've had a case before where there's been a fight, and one brought a claim for unfair dismissal, but the other didn't. And it was who started the fight and who kept it going that became the matter of contention. And the judge just said, a fight's a fight. You were involved in it. You should have been dismissed. So we knew by lunchtime we'd won the case because they were so adamant. Didn't matter who'd started it.
Yeah, and I think in the example used there, if that wasn't a work Christmas party, but maybe just for some people who went out out after work, that arguably may not fall into the misconduct category. It's not work time, it's not connected to work, it's something else. And if there's well, again, these cases you could be super careful with, but we'd certainly be looking to see whether we can substantiate a SOSR dismissal if that was decided in that case. And just finally, one we haven't mentioned is SOSR also pops up where we've got married couples working together as well, or people in civil partnership, and where somebody can be lawfully dismissed essentially if for something relating to the other person. I haven't got time for that now, but just thought I'd just mention it as well, because again, that may not be misconduct or performance, for example. Okay, it is now 5 o'clock. We promised we'll finish now. Thank you so much for attending. Really appreciate it. And as a quick reminder, the information we're covering today is accurate as of the 30th of June, 2022. We'll be back in July, and we look forward to seeing you all then. So until then, and that's goodbye from us. Take care. Bye-bye.
Bye-bye. Bye-bye.
Bye.